good morning, good afternoon, depending on what coast you're on or area of the country. Thank you for joining us for the final meeting in our series on justice responses to COVID-19. My name is Allison Lawrence, and I'm your host today. We will be exploring community supervision strategies during the pandemic, how practices have changed, and what the research says. Amanda Essex, NCSL's community supervision expert, will start with an overview of recent legislative trends. Kathy Waters from Arizona and Kelly Mitchell of Minnesota will join Amanda for a discussion. Full bios are available on our webpage. And we've reserved some time at the end for questions. I would like to thank the Pew Charitable Trust's Public Safety Performance Project for their generous support of this meeting. Amanda, next slide, please. Before we get started, I'm going to cover just a couple logistics. Karen McInnes is managing our controls. We have everyone on mute to ensure audio quality of the presenters. I encourage you to join me in taking advantage of the chat box function. The chat box may be located on the right side of your screen, or you can access it by clicking the word bubble symbol in the navigation bar. You can use that to submit questions throughout the meeting. I will also be dropping in a couple links that our faculties reference in the chat box, and there's a resources page for this meeting where you can also find those links, and I've given you the links to that page as well as the PowerPoint for today's slides in the chat box now. I will turn it over to Amanda Essex. Amanda?
Thanks, Allison. Good morning and afternoon, everyone. I'm going to start off with a quick overview of some of the statistics around probation and parole, as well as some of the recent legislative trends in community supervision policy. So you see on the screen here 4.5 million. That's the number of people who are under community supervision at the end of 2016, according to the Bureau of Justice Statistics. This chart comes from a September 2018 report from the Pew Charitable Trust Public Safety Performance Project, developed in partnership with Arnold Ventures, called Probation and Parole Systems, marked by high stakes, missed opportunities. The link to this report is in the chat box and on the resources webpage. This chart shows the rate of community supervision by state as of 2016. Overall, 1 in 55 adults in the US is on probation and parole. And as you can see on this map, there's significant variation across the country, ranging from 1 in every 168 adults in New Hampshire to 1 in every 18 adults in Georgia. Just last month, this partnership released a new framework to improve probation and parole. This framework is linked in the chat box, and it includes 7 objectives within which all of the policy recommendations fall. These objectives include 1, enacting alternatives to arrest, incarceration, and supervision. 2, implement evidence-based policies centered on risks and needs. 3, adopt shorter supervision sentences and focus on goals and incentives. 4, establish effective and appropriate supervision conditions. 5, develop individualized conditions for payment of legal financial obligations. 6, reduce the use of and pathways to incarceration. And 7, support community supervision agencies. We're going to hear more about implementing some of these objectives during our conversation in a few minutes, and we'll also hear how this framework is particularly relevant during this pandemic. A recent report from the Council of State Governments called Confined and Costly found that 45% of state prison admissions are due to violations of probation or parole for either new offenses or technical violations. And that report is on our resources page. According to Pew's research, more than 20% of people released from state prisons are sent back for technical violations of supervision, rather than the commission of a new criminal offense. A technical violation means that a person under supervision did not comply with some requirement of supervision. For instance, being late for or missing a meeting with their supervision officer or failing a drug test. Much of what has been enacted in recent years has focused on reducing these technical violations that contribute to prison admissions. Well established in law is the ultimate authority for sentencing courts and parole boards to make decisions on the disposition of supervision violations. Recent changes have established more prescriptive guidance, but they've also expanded options for responding to violations during the COVID-19 pandemic. One of the more pointed policies has been to limit the use of incarceration for probation and parole technical violations. As shown on this map, at least 31 states have limited the use of incarceration as a response to technical violations. In addition to short-term jail stays, these laws have created specialized facilities for violators in lieu of prison and capped the amount of time behind bars based on the number of violations. For example, a maximum of 60 days incarceration for a first violation, 90 for a second, and 120 for a third. The incarceration caps have evolved in many states into a full code section on what are called graduated sanctions. In statute, this looks like a framework of options that can or must be used instead of formal revocation proceedings. In addition to defining how long incarceration can last, other sanctions authorized include verbal warnings, community service, day reporting, electronic monitoring, and participation in treatment. On this second map, you can see at least 35 states have given supervision agencies, in addition to courts or parole boards, the authority to order graduated sanctions for technical violations. Along with this authorization, legislatures often change related statutes to support the principles of swift, certain, and proportionate responses. For example, allowing due process hearing requirements to be waived in order to speed up the time between the violation and disposition, putting in requirements that offenders be notified of the potential for sanctions, and delineating an order for which sanctions should be used, ensuring that they are gradually more restrictive and proportionate to the violation, swift, certain, and proportionate. Successful implementation of graduated sanctions relies on adherence to evidence-based practices, which we will hear more about from Kelly. Legislatures have supported implementation in a few ways: by delaying the effective date to allow for policy development and staff training, by appropriating funds for initial and continued training and codifying training requirements, and by requiring reporting on the status of implementation. The effective responses to technical violations have contributed to a decrease in prison admissions and an increase in the number of people on supervision. So the logical next step has been to explore the amount of time spent on community supervision. How long a person spends on probation and parole is determined by the court-ordered sentence, as well as any additional time ordered because of violations or unpaid restitution. The ability for courts to extend that time is rooted in statute that exists in most states, allowing the sentencing court to continue, modify, extend, or discharge a term of probation if justice is served by that action. States have capped the length of probation and limited the reasons for and length of extensions, and these caps vary greatly from state to state. States are also looking at ways probationers and parolees can earn an earlier discharge date. This third map shows states that have added statutory guidance for compliance credits or scheduled reviews. Both of these earned discharge policies can and do happen without statutory guidance, but the trend has been to codify. Compliance credits, are also called earned discharge credits, have been adopted by at least 15 states. And they function very much like prison good time. Credit is awarded on a monthly basis for compliance with the terms of supervision. Scheduled reviews are in place in at least 11 states, and statute sets out a timeline for when a review should occur, either after a certain amount of time has been served or as a percentage of the total sentence length. Both the credits and the review can result in a probationer being successfully discharged from supervision or transferred to administrative supervision status, meaning they don't have to meet with their supervision officer. These are just some of the legislative trends that we've seen in community supervision policy, and you'll see a link in the chat box for NCSL's new community supervision legislation database, where we're tracking significant enactments. And so at this point, I'd like to begin the discussion with our great panelists, Kelly Mitchell and Kathy Waters, who are going to be telling us about how some of these trends are playing out during COVID. As a reminder, please be sure to put any questions you have for our speakers in the chat box. And so my first question I'm going to ask Kelly. As I just highlighted, legislators have been quite active over the last decade with probation and parole supervision. As the executive director of the Robina Institute, you've been involved with research around supervision, particularly when it comes to evidence-based practices. Can you talk about the work you're doing at Robina and how that can help inform legislators as they look at shifts in community supervision during COVID? and would also love to have you offer a little bit of information about the recently released policy framework from Pew and Arnold Ventures.
Sure. Thanks for having me. I really appreciate the opportunity to talk with you all today. The Robina Institute does research in probation, parole, and sentencing guidelines. So I'm going to talk today about some of the work we've done in the probation and parole realm. You know, community supervision is a relatively new area of research. At the Robina Institute, we started back in 2015. One of our first efforts was just to compare probation rates in the US to that in Europe. You know, we already knew that the US was exceptional with regard to its prison rates, so we were trying to establish whether we fit the same pattern when you looked at probation rates. We compared the US and 50 states and the 50 states to 39 European countries, and we found that the US rate was more than 5 times the rate of the European countries combined, and that the probation rate in every US state was higher than all but 3 of those 39 European countries. Following that, we started taking a deeper dive into how probation works. The current trend in probation and parole and in government is to focus on evidence-based practices. That means focusing your time and resources on practices that have been proven to work through research. And so the purpose of the research in this area that we do is just to figure that out, what works. Back in the 1970s, Robert Martinson published an infamous report in which he reviewed 200 correctional programs and found that they had very little effect on reducing recidivism. The report was interpreted as meaning that nothing worked. But what he was really saying was he couldn't tell. He couldn't tell whether the issue was that people couldn't be rehabilitated. He couldn't tell if the problem was that we were delivering the wrong programming or if we were delivering the right programming in the wrong way. So that's what the research over the past several decades has been focused on trying to ferret out. Evidence-based practices in community supervision are based on matching the right intervention with the right people at the right time and in the right amount. Recently, Robina partnered with the Pew Charitable Trust and Arnold Ventures to research the policies and practices that were considered for inclusion in the framework. That framework sets forth multiple policies that states and supervision agencies could enact to improve community supervision outcomes. So as we work through this pandemic, the research from that framework, the research and the framework can help us focus in on what's really important in community supervision and the things we need to find. So those are the things we need to find a replacement for, like a new way of doing under this different system, and as well as the things that we could let go of, which things are not as important or as effective. So I'm going to tell you just a couple of things that rose to the top in terms of the research. Like, these are the things we don't question too much. First of all, one of the most effective frameworks for community supervision is the risk needs responsivity framework. That means before a person's supervision starts, the probation or parole department assesses a person's risks and needs. Risk refers to the risk to reoffend. People who are high risk are the ones who can most benefit from interventions and monitoring, and these are the people that we should spend more time with. People who are low risk, on the other hand, research tells us that if we over-supervise those people, we can actually make them worse. We can actually increase their propensity to commit crime. So those are the people we largely want to leave alone. So as we think about the pandemic, supervision agencies need support and help to find ways to maintain contact with the people who are high risk and largely leave alone the people who are low risk. So risk tells us who we should be supervising and where we should be putting our resources. Needs tell us what that supervision should look like. Needs refer to criminogenic needs, and those are the factors that lead people to commit crimes, and that also can be changed if we intervene. For example, does the person have antisocial thinking? Do they have a substance abuse problem? If we can identify those needs, we can identify appropriate programming to address those issues and reduce their risk of reoffending. So during the pandemic, continuing to connect people to appropriate programming is really important. And before I leave this really brief discussion of the risk needs responsivity framework, I just want to emphasize that this only works if the supervision agency is using a risk assessment tool that is periodically validated on their supervision population. And validation just means that we actually do the research to see if the people that we're predicting to be high risk tend to be the ones that are actually reoffending. We want to make sure it's working for our population. If the tool isn't validated, we run the risk of over-classifying people into higher risk levels and then over-supervising them. And as I mentioned before, that can actually make people worse. Finally, the last point I want to make is that we also know that the relationship between the supervision officer and the person on supervision is critically important to that person's success. People on probation and parole do best when the officer serves as a kind of coach, holding them accountable, providing firm but fair direction, but also allowing them to have some input and agency in the process. Every interaction between the officer and the person on probation or parole can color that person's chances of success in supervision. So it's really important to provide probation and parole officers during this time with support so they can maintain that connection and have the resources that they need to support people on probation and parole. So I will stop there, and I'm sure we'll talk about more pieces of the framework and more research as we go along through the webinar today.
Thanks, Kelly. And so, Kathy, we heard her mention a couple times supervision agencies, and as the division director of the Adult Probation Services Division, you're overseeing the boots on the ground for supervision of probationers in Arizona. Can you please share some background on the office you oversee? Tell us a little bit about the probation system in the state. Describe the major actions you've taken to respond to the pandemic and why you've taken those steps.
Okay. Thanks, Amanda. And a lot of what Kelly said really kind of leads into, so I'm going to just give you a little bit of history. I've actually been in Arizona as the state director of adult probation for the past 19 and a half years. And probably within the first year, we began the work that Kelly talked about. But first, let me tell you, probation in Arizona is under the Supreme Court. We have a unified court system, and so I'm basically the state director that oversees the adult probation departments in the 15 counties. There's one superior court, but there's a superior court in the county of, say, Maricopa, Apina. And so there's chief probation officers in all 15 counties that actually serve at the pleasure of the presiding judge. So that's a little different than some systems. Some systems are community corrections, are probation and parole combined under the executive branch. But in Arizona, probation is under the court. I actually worked in another state where I was a probation and parole officer, and I worked for a Department of Corrections. You know, and after I've actually been in Arizona longer, and people ask me, you know, what's the better system? Where does it really fit? And I would say, you know, not because I work for the Supreme Court, but even when I worked for a Department of Corrections as a probation officer, I served the court, the conditions of the court that we're going to talk about, and that's in the framework. So I believe that Arizona has a great probation system. It had a good system when I got here, and I would like to think 19 and a half years later, we're kind of seen as a model because of some of the outcomes that we've had. Like I said, Kelly talked about a risk assessment. When you really start working towards evidence-based practice, and when I got here, it was fairly new in the country. We knew that the 8 principles of evidence-based practice was out there as a guide for us. So this is in 2001. In about 2003, we embarked on a new 3rd generation risk assessment, if you will. It was in our Code of Judicial Administration that said there would be a standardized risk assessment used in all 15 counties. So that was to my advantage. But it was that we had to decide what risk assessment, and as Kelly said, it had to be validated for the entire state. And so back in the day, data was not as readily available. We didn't have automated systems. And so we basically went out to every county and gathered the data and sent it to the researcher to have it validated. Was the offender screening tool that we used really validated for the state of Arizona to be used statewide? It came back, it was. And we then at that point started implementing it. You know, what I would say about evidence-based practice is that it does base it on risk and needs, as Kelly said, but it's not a one and done. We've spent endless hours and lots of time and the commitment to stay true to the fidelity of our risk assessment. What the research says is that it should be revalidated about every 5 to 7 years. Is it still working for you? Well, I can tell you that we just last year finished our third validation of the risk assessment for the state. Some of our outcomes were very good. We knew that we had strong fidelity among the officers. That means, is everybody scoring this risk assessment according to the scoring guide, according to the research? We've invested a lot of time and a lot of officer time in not only training on evidence-based practice as the first class they get at our certification academy, and then every year probation officers have to go through a refresher or booster training of our offender screening tool. So I personally have been to every county numerous times training. What happened after this third validation, we were going on our revalidation tour, if you will, and going county by county to train on risk, needs, what the research said about our assessment, how to use the assessment in regards to high, medium, and low risk, how that impacted our policy, how that played into, as Kelly talked about, the risk and the needs, more importantly, how the needs feed into the responsivity and the case plan developed with the officer and the probationer. And as Kelly also said, I liked it that she said, you know, more of a coach. We've spent a lot of time giving officers the skills to really coach and look at the risk and needs and writing that case plan that really what we're about is reducing risk. And so the case plan really should drive how the supervision happens. There's conditions for probation, but the conditions can sometimes be prohibitive or counter to what the needs are of the probationer. So we tend to focus more on within those conditions, what is it that the offender needs? The pandemic caused us, we were about halfway through our training. It caused us to, prior to our stay-at-home order, my staff and I went into a recording studio and we did audio of our presentations and linked those to our PowerPoints. So half the county got the live presentations, the other half of the counties got the taped presentations. But our training went on and we're now ready to launch our new automated case plan later in June. What it also did was we just looked at alternative methods of meeting all of our standards. It was not business as usual, but public safety was first. The health of not only our probationers, but our officers came into play. We allowed, and we had already put into our policy about a year or more ago, that we allowed remote access reporting. So that meant they could use some sort of video type. So that allowed officers to use Skype, FaceTime. They would still do home visits, but they would text the individual, I'm at your front door, or I'm in your front yard, please come outside. And they would do their face-to-face contact and home visit that way. So those were some of the ways that we adjusted, but we really didn't stop doing supervision. But many years ago, we really, by our Code of Judicial Administration, we scripted our policy to tell officers, this is how you supervise minimum, this is how you supervise medium, this is how you supervise high risk. And by doing that, we didn't, as Kelly said, pay attention. Holding lower risk people accountable is much easier and doesn't take a lot of resources and officer time as those we really needed to focus on who were higher risk because of higher needs. So, if you base it somewhat, I always compare this to a medical model. If you go to the doctor and you have a headache, it might just be, you know, the weather's changing and you have a sinus infection versus a brain tumor. Well, you wouldn't approach those in the same way. So you really intervene at the level of what's needed to correct and reduce that risk. And the risk is that risk of reoffending.
Well, thank you. And I want to kind of use something you just said here. You mentioned the importance of the health of the officers and probationers, and then you also mentioned you're still doing community supervision. And that individuals and our communities is at the forefront of everyone's minds right now. And public safety is a cornerstone of community supervision. So this question is maybe for both of you. Can you talk about how these two goals of public health and public safety either work together or compete against each other?
Sure. Do you want to go first, Kathy, or you want me to?
You can go ahead and then I'll build on what you said. It worked out fine.
Well, I actually want to tell you about some research that we just put out. I actually recently participated in some research with 3 other professors here at the University of Minnesota. It's Dr. Tyler Winkleman, Dr. Rebecca Schlafer, and sociology professor Michelle Phelps. And we were studying the prevalence of health conditions among people on probation and parole. I think it's probably common knowledge that people who spend a lot of this, or spend a significant term in prison tend to have poorer health outcomes than the general population. What we were trying to look at is, well, how does that compare for people on probation and parole? Do they have the same health as everybody else because they're not spending that time in prison, or is it different? And so we actually did some research on that question, and we found a couple of really interesting things. One is that, obviously the population on probation and parole runs a bit younger than our general population. So you'd kind of expect their health to be better, but the reality is that for people on probation and parole, and this is from a nationwide sample, they actually experienced either the same or worse levels of chronic conditions, including asthma, diabetes, and hepatitis C, things like that. So we actually have a population here whose health is a bit worse than the general population. So I think for me, that means, and they also tend to have less access to healthcare. When you kind of put those two things together, it's a situation where, I think you really have to think about what are the requirements that we're asking people on probation and parole to adhere to, and what are the health risks to them for adhering to those things. So for instance, I'm probably going too far into the weeds here, but on one really common condition on probation and parole in many parts of the country is to require random drug testing, regardless of whether the person has a substance abuse problem. So if you think about what does it take to do that random drug testing, you're going to have to go somewhere to leave a sample. So you might have to take public transportation. You're definitely going to have to go out there in the world. You're not going to be able to shelter at home for that. So you're putting people who probably have a worse health profile at risk every time you're asking them to go out to do a drug test. So one of the framework, pandemic aside, actually recommends that we limit drug testing to people who actually have a substance abuse problem, and that we use it to help identify those times when people are struggling and need some help with treatment. That's the way to get to public safety, right? Provide those interventions so that people can get the help that they need and to reduce their risk of reoffending. So I actually think there's a big interplay between health and public safety in the way that we supervise people on probation and parole. Probably a long way to answer your question, but that's one point of view anyway.
Yeah, and so I will build on that. In Arizona, we're lucky that we are a Medicaid expansion state. And so a lot of our probationers are what we call access eligible, which is a good resource for us. And, when you talk about risk and need, we also talk about what it does is categorize. And if you look at the history of individuals, a lot of them come from, low economic background, then, the access to healthcare and all of that plays in just through generations. And so really looking at how can we reduce, if they're not healthy, it's not just mental health, it's the substance abuse, and all of the other things that Kelly talked about. So you have to really approach it in that way, that that is really part of their needs. And, you know, it categorizes into the sections of the risk assessment that really can get there as far as physical health. And that doesn't play as much into, physical health is not one of the items. We ask the question, but we don't score it, because there's no correlation between recidivism and that. But if you think if someone is going to be required to do community work service, or you know, work and be employed and be successful, their health plays a big part of that, and their family health. And so we rely on our access, and we actually have what is called high impact centers. And these are, there was a Medicaid expansion that allowed these centers that actually they can go into to get dental work, physical health, all of those items. Excuse me. So that's been a big asset. Most of us have what we call protective factors. We have all of these pro-social things that help us be successful. And the people that we have under supervision are not only lacking in some of the higher risk categories, but the health issues as well, which translates to them being successful, which translates to public safety.
Thank you for that. And a couple of times we've heard a few examples, but one objective of the policy framework is to establish effective and appropriate supervision conditions. Some conditions that are imposed on individuals, like we've heard in-person check-ins with their supervision officers, treatment and skills classes that generally require that person-to-person interaction, really aren't feasible or safe in this current climate. How have some of these conditions been adapted or modified, and are they still able to adhere to evidence-based practices?
Do you want me to take that, Kelly?
Yeah.
So we have actually, you know, a lot of the research and data, and I think when you start moving towards the direction that we did with evidence-based practices, it really launched us into more standardization. We have standardized conditions of probation statewide. So as we look at those conditions, we're able to do that on a statewide basis, and it's actually in our Code of Judicial Administration, or in our policy. So we have really touched on, you know, you try to tie the conditions to probation, and sometimes what the conditions do is that it paints everybody with a broad brush rather than being individualized. And what the research and the evidence-based practices do is really individualize the conditions. And so we really have to work within the realm of the standard conditions, but weave in the risk needs. And one of the things that we did back in about 2009 under Chief Justice Ruth McGregor, who actually was the Chief Justice who adopted evidence-based practice under the Supreme Court, and said that our Supreme Court would do what the research says. And she actually created a Center for Evidence-Based Sentencing. So what we actually did at that time was embed the risk needs assessment into our pre-sentence report. So when the judges get the pre-sentence report, they can take a look at that, and instead of just checking the boxes of everything they want and everything they want people to do, or everybody gets the same conditions, they can actually look at the risk assessment and order that individual to those special conditions that apply to reducing the risk that is given to them in the risk needs instrument. So that's some of what we've done ongoing. I think what we've had to do during the pandemic is not that we turn a blind eye to conditions, but there's what we call technical violations, and then there's new crimes. You know, and our number one goal is public safety. If you reduce risk, you reduce reoffending. And so, you know, reporting became very different. It was the officers, we actually stopped office reporting statewide. And so the officers then did Skype or telephone calls or texting, or if it required a face-to-face, like I said earlier, they were able to do that in an alternative way. Everyone was on a stay-at-home order, so unless they were leaving to go to work, it really actually enhanced the officers' ability to contact them where they were. So the technical violations would be failure to report, or perhaps not showing up for a UA. Some people would argue that a dirty UA is a new crime, but sometimes it's not charged that way, especially if they have an addiction. You can expect someone to have a dirty UA if they're dealing with their addiction ongoing. So really our goal was, the county jails tried to release individuals on pretrial status, and those that were on work release, get everyone out of the county jails that they could and keep them on home confinement if they were on work release. So why would we all of a sudden do things that were going to incarcerate more individuals, especially for technical violations? The only time that we really would issue a warrant and ask that the person be incarcerated would have been for a new crime and when public safety and there was a danger to the public regarding that. That doesn't mean that we turned a blind eye to those technical violations either. We just re-engaged and tried to work through them to try to bring them into compliance with those violations.
If I could just add something there, at the very beginning, Kathy was talking about, tailoring those conditions to the person's needs. And I think she's being a little modest, because I know that one thing that Arizona has done and other states have done is also look at their standard conditions and try to pare those down. Like, what are the minimum number of conditions that we really need in order to conduct supervision? That's the basic stuff, like maintain contact with your supervision officer, right? So a few of those things have to be there, but then really take the rest and focus those on the individual and on their needs, and try to limit the number there too. So it's kind of a twofer. You wanna make sure you hit those standard conditions and reduce those as much as possible, and also make that connection of the special conditions to the person's needs.
And what I might add there, Kelly, is that sometimes, more is not better. You really need to do the level of risk with that individual, more requirements. But sometimes we put so many requirements on individuals. There's only 40 hours in a week, and we set them up to fail rather than setting them up to succeed, and working with each individual about what's going to work for them to help change that behavior that led to the crime.
I have a couple other questions, but I think I want to check in with Allison, see where we're at. Maybe we want to go into some of the audience questions.
Yeah, I would say, just looking at some of them that are coming in, building on the conversation that you're having on conditions of supervision and technical violations. One of our attendees is curious specifically about employment and fines and fees, and how supervision agencies are dealing with those requirements, given working at home, many people are furloughed during the pandemic.
Yeah, do you want to start with that, Kathy?
Yeah, one of the things that also is in the framework that we looked at, and we're still ongoing working on that as well, is looking at the ability of individuals to pay, and building that in and have a standard way of weighing, what's reasonable, what can they pay, what can't they pay. So that's kind of ongoing. We want everyone to be using and considering the ability to pay. But, we have the ability, that would be seen for us as a technical violation. And I think you have to individualize what's going on with the individual if they're not working, if they're not drawing unemployment, if they're on, what can they do? And they're trying to survive. So working with them, we do have, we came out with a policy after our Supreme Court had a Fair Justice Task Force and looked at reducing fees and fines. across all boards. I mean, not just those under Superior Court supervision, but all court cases. That are we imprisoning people, or it should be the ability to pay for any fee and fine. And so we built that into our policy, that individuals cannot be revoked to prison or jail because of fees and fines. We have to establish an inability to pay. So that's one thing that we did incorporate into our practices. And just working with the individuals, and we have the ability to extend their probation. Restitution is another thing, because we want to be victim-centered as well. And so that, aside from fees and fines, we would probably prioritize the restitution first, and then work with them through the rest of the fees and fines.
At the Robina Institute, we actually are engaged in a project right now to assess the additional load of fines and fees that are imposed during the period of supervision. I think most people are aware that when a person's convicted, there's often a fine that goes along with that conviction, and there might be court costs or attorney's fees that the person has to pay. But I think fewer people are aware that the fees keep adding up when you're on supervision. A lot of supervision offices have to charge a fee to people for their services. So there's a monthly supervision fee that people will pay. Sometimes people have to pay for that drug testing. Sometimes they'll have to pay co-pays for the programming that they're required to engage in. It really, there's a whole another variety, another box to open when you're on supervision. So the problem is it can be even more compounded during a period like now. And then if you sort of look at, well, what are the options if you can't pay those fees? Some states still revoke people's licenses for failure to pay. So I've seen a trend in reversing that in many states. One thing that I think is really important to think about here is, actually, I lost my thought, so I don't know what I thought was important. But one thing that I was actually really amazed by, I live in Minnesota, I live in Ramsey County, Minnesota, and during the pandemic, Ramsey County actually waived all their fees for people on supervision and decided that they would stop collecting supervision fees. It was a bold move. I couldn't believe it, but it was pretty amazing, because they recognized that the people that they had under supervision just didn't have the financial means to do that. And their goal was public safety, which is providing services and interventions to people on community supervision. So that's certainly an option for dealing with the fines and fees issue too.
Yeah, and what we found is, sorry.
No, go ahead. Go ahead.
Giving the court, if there are things that can be waived, giving them the opportunity to actually advise, an inability to pay and what can be waived. And then also, there may be ways that they can, if they've been involved, like our community service hours, you could have those in lieu of, and we've calculated a price that they could do some more community service and work off those fees and fines. So any way that we can be creative and to do that, to assist the person, we have done that as well.
Great, thank you both on that one. Another question that maybe Kelly's for you, but either one I'm sure can answer it. Is there information out there on how to effectively service those who are low risk, high needs?
That's a tougher one, right? Because the way that most supervision is structured, that we spend our time with people who are high risk. And low risk, high needs is a bit of a different, I don't think we have the perfect answer on that group yet. I'm actually going to kick it over to Kathy to see if there's anything that you do specifically in your jurisdiction for those folks.
Yeah, we actually have it in our policy that if they score within a certain domain of the risk assessment that's pretty high, but overall they still come out as low risk, then we still have to address those issues. So the case plan still has to work with that individual. You may not have to have as many contacts with that individual, but contact doesn't, unless you're assisting them with the need, that's where the contact should focus on, is really working on that need.
And one of the things that's really key with people who are low risk is they're going to tend to be people who have the social supports in place and employment that Kathy talked about earlier. So you want to, if you're going to provide that service, you want to do it in a way that doesn't interrupt the good things that person already has going. That's really the key there.
Thanks. One last question. Much of what you've talked about, and you've sort of touched on this, takes support and training on how to, for the officers, training on how to interact with probationers, training on how to properly administer assessments. It sounds like a lot of work, pandemic or not. What does your quality control look like? How can folks ensure that evidence-based practices are being adhered to?
Do you want me to take that, Kelly, first?
Yes.
Okay. I would say data, data, data. In the early days when I was trying, you can imagine, trying to change a culture, and some of the culture, was very punitive. And so trying to change that within a court system or within any system, it takes a lot of training. And it wasn't until I could get the data, when I came in and said, we want to supervise these people this way, and if they're low risk, we really don't want to do a lot with them. Well, you can imagine how that went over. So, everybody, there's conditions of the court, there's supervision, we have to do this. So it was when I could show through the risk assessment how many people we really were kind of upside down, showing that we were over supervising people. We had low risk people on IPS, which is our intensive program. And the majority, the majority of people on IPS were low risk. So we actually were doing damage. And so it took us showing that data to drive our policy. That in conjunction with, we took a look at the corrections population of who was going to prison. Well, when we did a violation study, and we saw that 43% of the people going into the Department of Corrections were coming from us on probation. And of course, the chief probation officers were pretty defensive and said, that has to be new crimes. It has to be. We wouldn't be doing that. When we really drilled deeper into the data, 80% of that 43% were technical violations. And so what I would say is, we had to change our behavior before we could change other behavior. So getting everybody categorized and assessed properly, and then the supervision strategies that followed. And I can say, you can look at our data over time that the Council of State Governments and others in our Safe Communities report, we actually flatlined the prison population in 2 or 3 years. So that was significant. But to Allison's point, we had to do lots of training. We had to train not just probation officers. We had to train the judges. We did multiple trainings for judges. We engaged the defense bar, and we engaged the prosecutors. And the Chief Justice and I actually went and, we spoke to the legislature. And they loved it when they saw our outcomes, because we know what corrections budgets can be. And when we were, reducing the prison population, and we played a part in that, that was quite significant.
I think too, you can't underscore the importance of that relationship with the bench that Kathy just described. I mean, she's lucky, she's in the judicial branch already, so they have a natural relationship. But if there's not a good exchange of information between the bench and the probation department, then the sentence and the conditions that are imposed by the bench can actually be run counter to what we need to do to effectively supervise people. So when she talks about training everybody, I love that. I think that's exactly what we should be doing across the country. We should be engaging all parts of the criminal justice system, so we're all working towards these goals.
Thanks. There's one more, Amanda, if we've got time, that's come in. Kathy, probably best for you. Are you leveraging technology during the pandemic, or are you using it more, such as electronic monitoring, electronic check-ins?
Not really with the electronic check-ins. Beyond the Skype, FaceTime, texting, you know, one of the things that we've learned from this is that the need, and actually we've applied for our state grant with the COVID monies to get laptops for all of the probation officers so that they can not have to come into an office but be remote and still connect to our case management system, to our criminal justice systems, so they can really do their work and not put themselves at risk. But we also learned that our access for our treatment providers allowed there to be teleservices, but our providers were reluctant to do that. But this has really now helped them. They know now they have to provide telecounseling and teleservices, just as all of us, if we went to our doctor, you know, you would have a Skype call with your doctor or doctor on call. So I think that technology will be ongoing. I think this whole pandemic has taught, the last thing that I know, we tried to get away from fortress supervision of making it harder on the probationers to report in and get officers out into the field and going to where they are doing those remote connections. This has helped us go back to that. And the probationers, I think, appreciate it, that they're being checked on. How are you doing? It's not just about the compliance, but how are you health-wise? How's your family? Are you doing okay? Especially those who are experiencing substance use. We're seeing an increase and an uptick in that as well. But I just think that it's just going to make supervision be approached in a very different way now. And we'll have to rely on the technology to get there.
On that note, I do have a couple of a final question for each of you to get some final thoughts before we finish. Kathy, this has really kind of been the undercurrent of a lot of what you've said, but you've been undergoing reform work in Arizona. What are some of the recommendations coming out of those efforts that could potentially be moved forward because of COVID-19?
Well, we've been able to have work group meetings. Nothing has stopped. So we've had team meetings and ongoing. I have a judge who's helping me work with the conditions of probation to really finalize those. Even though we've made them evidence-based and reduced them in the past, we really want to take another look at them again. But it's hard to do that without the judges understanding why we want to do that. So I think that's our first, is to do some training with the judges and then engage them in that work. We are working on our ability to pay and a standardized financial form that goes to the court. So that work is ongoing. We have an IPS work group to really refine how can we improve our outcomes on the probation. And then lastly, we're looking at more standardization of early termination of probation. One of the things that we did back under Justice McGregor when it was the budget issues in 2009 or 10 was that she asked the court to take a look at cases and those individuals that could be early term and moved off of supervision safely should do so. Those who are on intensive supervision, take a look at those, move those into more of a standard supervision. So it's really working through our resources and supervising those individuals that really need to be supervised rather than just keeping those individuals on who can be okay on their own and have met all their conditions.
Thank you. And Kelly, last question here for you. Got a couple minutes. Really big question. What final thoughts or observations would you like to share about how states have been able to respond to COVID-19 for justice-involved populations?
I think that, you know, I've heard anecdotally what some community supervision departments are doing to respond. to the pandemic. And one thing that I thought was interesting was, people who were serving jail terms, and I think Kathy mentioned this in Arizona too, they were serving jail terms, but they were leaving the jail every day to go to work. And those people were released and put on home, either electronic monitoring or home confinement. And I think that that's making folks reconsider, like, do we have to have them in jail if that's what we're going to do? If we trust them to go to work, do we need to have the jail to confine them in the evenings or whenever their work shift, whenever they're not working? The other thing I've heard, here in Minnesota, we had a couple of counties that really had sort of a trigger response to violations, and 30 days in jail was a real common sanction, and they can't do that now, right? So they've agreed not to do that now. And I've heard, even from prosecutors, I don't even know why we ever did 30 days to begin with. Maybe we don't need that at all the next time around. Or maybe we think of something less than 5 days, something that's not going to interfere with that person's employment and housing situation. So those are really encouraging. Those are really encouraging signs. And I think that what it all boils down to is that the pandemic has made us all realize that less is more. I think all of us in our personal lives have had to sort of shed the things that aren't important so that we can get the things done that really have to be done, because it's a little bit harder to do it in the situation that we're in right now, right? And community supervision really isn't any different. Like, it's a great opportunity to think about which things do we really need to keep doing the way we've done them before because we've always done them that way, and which things could we sort of let go of and try in a different way, or keep the different way we've been doing it going in the future. So I think that's what I take away from this.
Well, I really appreciate you both taking part in this conversation today. I've really enjoyed that. And I'm going to go ahead and turn it back over to Allison to wrap things up.
Great.
Well, thank you. Thank you so much, Kathy. Thank you so much, Kelly. Great discussion today. I'd also like to give a special thank you to Amanda, as well as the staff at the Pew Charitable Trust. They've all helped us to design and produce the entire series of these virtual meetings. If you want to check out previous virtual meetings that we've done, the recordings are up, and I've stuck the links in the chat box. We hope you've enjoyed this. Please call on CSL anytime. Thanks, and have a great rest of your day and week. We look forward to talking to you soon.
Thank you.
Thank you.
Thanks.